Hey everybody, good morning. I'm JD Hoopner, your host of the Bold Today show, and you made it. This is our live Q&A session. I've got some special guests. I've got three actually coming up for you. So we're going to be getting to that in just a little bit. I'm the owner here at Bold Patents Law Firm, and I'm here every week at 9 a.m. Pacific and noon on the East Coast. So if you're watching this after the fact and you missed us, catch us next week. We're going to be there. We want to hear your live questions. But this is not, of course, the forum to share confidential information. This is a public forum, public broadcast. So I'll put my quick disclaimer in here. By nature of you joining the webinar and being here with an attorney, you're not a client, unfortunately. But if you're interested in becoming a client, I will provide a link later for you to take action and get that scheduled. So without further ado, I want to bring on our guests. I'm excited to have both Uche and Phil here from Parachor Consulting. And they've been backstage waiting patiently. So let's bring them on right now. Uche and Phil, good morning.
Good morning, JD. Thanks for having us.
You bet. Thanks for being brave and coming on a live broadcast. We are going across LinkedIn, YouTube, and Facebook. So I'm hoping we can get some live questions. We will prioritize any of those that come in. So you guys will be on the hook if we get a live question about what you're up to. But I want to let you introduce yourself a little bit first. So Uche, why don't you go first? Tell us what Parachor Consulting does and how it relates to R&D tax credit.
Yeah, so my name is Uche Okoroha. I am an attorney, and I'm one of the owners at Parachor Consulting. And essentially, Parachor Consulting is a tax advisory firm that specializes in the research and development tax credit. We will calculate and we substantiate, and then we also defend R&D tax credit audits.
Awesome. That sounds really good. I didn't know you're an attorney, Uche. Maybe I knew that and just forgot that. So you're an attorney on top of that.
Yeah,
Very
absolutely.
cool.
An attorney by background.
And good. I'll bring on one more attorney here. Familiar face, Matt Colseth. Welcome to the show. In-house trademark counsel for Bold. Thanks for coming.
Hey, morning, fellas. Nice to meet you, Uche and Phil.
How are you?
Hey, Matt. Great to meet you.
Yeah, likewise.
Phil, I want to give you some. Oh, absolutely, Phil. I want to give you some time to introduce yourself. Would you mind doing that?
Yeah, my name's Phil Martin here. I'm the Director of Business Development with Parachor Consulting, and my main responsibility is really to make connections and drive new business for Paracore. So it comes down to me making connections and introducing our company to people and companies that qualify for the research and development tax credit, as well as being the quarterback really for our partnership program, which is how JD and I originally got connected.
Very cool. Very cool. Love it. Well, thank you for coming on, both of you. Let's start with the question of Paracore. That actual name, how did that come up? How did you guys come up with that name?
So actually a kind of interesting story here. So when we first started the company there, we were, trying to come up with a company name, and we were really just taking a look at obscure words, in the English language. And, we came across Paracore, and Paracore is actually an engineering concept. I think it's like some kind of an empirical concept for surface tension. We were like, oh, okay, that's kind of strange. It's kind of unusual. But, at the time, Paracore, our main target audience is architects and engineers. And we were like, hey, there's this, very beautiful sounding engineering term there. Our main target audience is engineers. So we just kind of rolled with it from there.
Very cool. Yeah. So tell me, how do you work with engineers and architects? What's sort of the slam dunk, you're in your wheelhouse, perfect kind of client?
Yeah. So, like I mentioned, architects and engineers definitely where we started off there. And then we moved into, manufacturing and technology, which we'll get to that as well. But initially with architects and engineers, essentially we're looking for any type of industry that's using their background in the sciences to solve problems there. So, typically, architects and engineers, as long as they're creating original designs there, every project that they're working on is new and it's original, whether it's commercial, whether it's residential, whether they're working on, shopping centers or, hotels or anything like that. Typically we're okay to work with all of those companies there.
Got it. We got our first live question. Peter Bucklish, sorry if I'm mispronouncing, with the FFA and the FIPA certifications there behind his name. Can a UK resident, going international on you, claim an R&D credit for patent costs in the US? What do you guys think on that?
Yeah, that's absolutely a great question. And if you are a UK resident, the first thing that I would be asking is, if you do own a company that is within the US, or if you are subject to any US taxes, because with the R&D tax credit, of course, we are talking about offsetting your US either income tax or your US payroll taxes. So that'll be my first question. Are you subject to any taxable liability within the US? And then number two, do you have those expenses that are incurred within the US? Because the research and development tax credit is meant to incentivize keeping all of that technical activity, within the US borders. So if you have those employees, that are doing work within the US and you are subject to US taxes, then absolutely that is something that you could take a look into doing.
Okay, so I'm just going to walk this through. I'm going to put myself in Peter's shoes. So I'm guessing he's based in the UK, but he's getting a patent in the US because he wants to get the US market. What if he doesn't have a business set up in the US, but either has or hopes to have a stream of income, right? Licensing that patent to US-based companies. What if he's still 2 years out? Can he do anything now to prepare for that future revenue stream and that, like you said, tax liability in the US?
Yeah, absolutely. What it would be right now is getting your basis started and getting your documentation collected. With the R&D tax credit, documentation is the most important thing. So making sure that you have really a record of what's happening as far as when you're when you're developing your product there, and what type of expenses you are incurring. But that's the biggest thing. You need to be incurring expenses in the US. So whenever that happens, start to record that. I know overseas, they have their own different types of research and development tax credits, that we don't specialize in. But I would say that for the US market, just keep a hold on those records there.
Perfect. I'm going to keep these coming. And Phil, if you want to jump in, you certainly may. So Entrepreneurs Are United, love that name, asked the question, if you have an application, where do you start in protecting your business? Now, I'm not sure if they're talking patent application or maybe an application for tax credit. Do you want to take this up first if there is an application for tax credit? Does that make sense to you?
Yeah, if you have an application, where do you start? In protecting your business. So, I think this is, definitely applicable, for patents there for sure. As far as claiming the R&D tax credit, in an application. The process would be, going through and figuring out, like I mentioned, those expenses that are going into those mobile applications. And also, I think it's a good time to talk about if you're doing a mobile application, how you set it up so those expenses do qualify for the tax credit. We do have a lot of companies that come to us when they're developing a mobile application and they are outsourcing, some of that work overseas. Typically those expenses wouldn't qualify. And even if it is in the US and you're outsourcing it, make sure that these development firms, even if they're charging you like one fixed fee, for them to actually split it out into hours, because only those hourly expenses for those contractors would be the type of expenditures that qualify, as well as any W-2 employees too.
Wow. Okay, that was a lot. That was a lot to unpack. Okay, so I think what he's asked, so if you've got an invention that you think is potentially patent protectable for a software or mobile application, if I might, I would say, hey, get with a patent attorney. Why not build patents, right? Have us explore patentability. Let's look into seeing if there is a actual viable way to protect what you come up with, your software solution. And being an attorney, being a law firm, we are just one of many ways to spend money and invest, right? So if you invest money into R&D, having us do research and having us actually help you file and protect what's patentable, those costs, I think to some degree, as Uche was saying, can be banked, if you will, or used toward offsetting some liability. But with bringing a mobile application to market, as Uche mentioned, you have to hire developers. And so use just what he said in that nature to document how you're incurring those expenses and investments, whether it's flat or hourly. So did I capture that okay? Does that make sense?
Absolutely.
Yep.
Okay, good. All right. Well, let's do it. So I want to move on. Thank you for that question. Oh, here we go. Just a follow up here. So they've used Bold before. Good job. Just want to make sure that it's a viable step for the app. Good. Glad you like that. Awesome. Keep the questions coming, guys. We're going to prioritize the live questions. I want to give you guys kind of the platform to share how Tax Robot, I've heard this Tax Robot fits into Paracore.
Yeah, so definitely with Tax Robot, what we were really trying to accomplish is taking the old and traditional method of tax credit consulting, which is very complicated. It can be time consuming. It could even be a little bit expensive, to be honest, and really revolutionize the way that we're taking a look at that, by automating that process with technology. So it's sort of like saying, hey, we're creating the TurboTax of specialty tax credits. So now, instead of having all of these conversations, with these consultants and going through this months long process, you can really log into the Tax Robot application there. You can answer a few questions, upload some documents, and the system will automatically calculate your R&D tax credit there. So that's what we've been doing there, with Tax Robot on that end.
Well, send me, what's the URL? Can we provide that to the listeners here?
Yeah, that's going to be taxrobot.ai.
AI. Okay. I'll put that right there. Check it out. And we've got a minute. I may just pop that in and share a screen and go there myself. Is that something we can go look at?
Yeah, absolutely. And Phil, if you can talk a little bit about the onboarding process, kind of how they move through that system there.
Yeah. So once JD pulls up his screen, it might be a little easier to see. But essentially, what we do here is, we want to make sure everybody has a really good introduction to this software. So once you get to this screen that JD has displayed, there's an option to basically sign up for a demo. It should be right up there in the top right-hand corner. So you click on that, you send in your information, which will come to Uche and I here on the back end, and we'll schedule a time to really connect with you, learn more about your business and, what you're looking to accomplish here in regards to obtaining this tax credit. And then there's a real easy to follow step-by-step workflow that we've developed here that asks some overarching questions about, the company, the nature of the work that your company is involved in. It'll ask about, those qualified research expenses we were touching on a little bit in regards to, are you paying any contractors, on an hourly basis? What is, do you have any full-time employees? So expenses of that nature, it really wants to dive into. And it also asks for you to upload some specific documents in regards to, tax returns, as a short example. So it's a great software that we've spent a lot of time developing to make it as simple and straightforward as possible. So we're really proud of it, and we'd love to share it with anybody and kind of walk them through a demo if they're interested.
Awesome. There it is. I put the link right there in the comments. Thank you, Phil. And so really, it's for anybody that has tax liability, and let's just be really frank there. That's anybody that has gotten net income, that's made some profit, and is going to owe taxes. That is, an automatic thing. But if someone's still at the early stages and they're still developing their IP and not even revenue positive, could they still fill that form out, or should they go a different avenue?
Yeah, I absolutely think they should still fill the form out, and especially with our software and technology firms, they kind of hear taxes and they start to tune it out. They say, "Hey, I'm not profitable right now. I'm not planning on being profitable for the next few years here. Why should I really care about taxes or tax credits or anything along those lines?" But actually, even if you're a startup and you're not profitable and you're not paying any federal taxes, you don't have any tax liability, you have to still consider if you have W-2 employees. Because if you do have W-2 employees, Uncle Sam still wants his cut. You still have to pay those employee payroll taxes. So instead of taking it against your income tax, you can apply the R&D tax credit against your payroll taxes. So we deliver that tax credit, and then those quarterly payroll taxes, you would just pay less, or sometimes pay no payroll taxes at all moving forward. And especially these young companies, these startups, that's really going to help you reinvest that into what matters, which is growing your business.
There we go. There we go.
Also, I think it's maybe worth mentioning here as well that there are about, and Uche, correct me if I'm wrong, about 30 to 35 states that have a state level credit in addition to the federal credit here. So we all know that, California and, Silicon Valley is a hotbed for startups. Just as an example, California has one of the best state level credits for the R&D tax credit. So there's that, in addition to the standard federal credit that people are entitled to if they're doing this kind of work.
Absolutely. And thank you for mentioning that there, Phil. Especially with all of those technology companies, like you mentioned in California, I would say a good chunk of our clients are out in California because they pay, so much in-state income taxes. So, you are able to go back and claim that tax credit. And, in California as well, there is a 4-year statute of limitations to go back and amend, even for previous years, where you did miss that benefit. On federal, 3 years to amend those prior years.
Good stuff. So it's not too late, even if you have filed taxes already going back 3, even 4 years. Cool opportunity. I sounds like there's a real good incentive to keep things in the U.S., right? And this is what it's all about. And to think twice about hiring a contractor and doing the full W-2 employee. You've got the potential upside.
Absolutely. And, that's going to be, on a case by case analysis, with each individual company, hey, do we outsource, do we keep it in the US and claim this very, beneficial tax credit here? But I will say that we all know what happens, on Capitol Hill and the arguing back and forth. This is one of the only issues in the history of politics that both sides of the aisle are like, yeah, actually, this is something that's very good, something that we can agree on. And that's why they did make it a permanent part of the tax code there in 2016 with the PATH Act.
Awesome. Really good stuff. We're going to have you guys back on. I think I said that last time. Is it okay if I give our viewers your guys' email address if they want to reach out directly?
Yeah, absolutely.
Absolutely.
Okay. So please contact you guys on email. And I've got that link to the taxrobot.ai. So there's your email. We'll put you guys backstage in case we have time, in case we have any other questions. But let me thank you both for being on and being brave on this live broadcast with us.
JD, I appreciate it. Thank you so much.
Thank you very much.
You're welcome. All right. Matt, all right, let's do it. Thanks for hanging in. That's cool. I mean, I'm like, every time I hear about that, I'm like, why am I not telling all of my clients about this?
I had
For some reason, I just, yeah.
It's because, law's complicated, right? And there's just a million different pathways, right? And that was really interesting, though. I had some idea, but no idea of that level of knowledge.
Yeah, well, it's good to just spot the issues, send our clients to people like them that can help them, save some money for our bills. For heaven's sake,
it's cool that Uche is a tax attorney too. That's helpful.
Absolutely. Okay, let's break it way down. I got a really fun question here out of San Diego on trademarks on the Ovo group. Thanks for hanging in on this Ovo question. So here it is. How do you go about trademarking a barbecue sauce? I need to put some sauce in stores. So Matt, what's your tip here?
Yeah. So the barbecue sauce falls into like the foodstuffs category, like the perishable foodstuffs category, the USPTO. So we would, assuming that the trademark name is conceptually registrable and that there's no prior filed or registered trademarks that are similar in naming convention, we would file in the foodstuffs category. If they're in the marketplace already, it'd be an actual use application. We would choose between filing what's called a word mark or a design mark. Word marks protect the letters of the barbecue sauce, whereas the design marks can protect the logo, and we can protect either or both. But yeah, we would definitely want to take a look and see what's out there. in terms of the name. Obviously, we can't register, if you call it JD's Bold Barbecue Sauce, we can't register barbecue sauce or potentially JD's.
Okay.
It's because that's descriptive of you as the maker of the barbecue sauce and the nature of the sauce, which is barbecue sauce, right? So we can't register descriptive trademarks, but the Bold barbecue sauce, Bold, yeah.
Hey, don't give them any ideas. I mean, so you're saying that someone could right now go register, assuming there's not already, Bold barbecue sauce.
Totally.
Or is Bold? Okay, I bet it's gonna be good, right? Okay, so yeah, thank you for that. That's all.
Yeah. So that's a little bit about how I would approach, barbecue sauce.
I gotcha. If I see it on the shelf, Matt, I'm coming for you.
If I work with the client, I would require them to send me a sample for sure.
Yeah, absolutely. Okay, Peter, thanks for your question. Yeah, we just did. We sent that email address for Uche up above, so check that out. And Uche, I'll send both of you and Phil his email address if you see that in the comments for Peter. So he has some follow-up questions. All right, let's do a second trademark question. Let's find one a little bit. This one looks a little bit more detailed. Okay, so from Anaheim, California. This is a long one. We'll send it in chunks. We'll send it in chunks here. Someone's midway through, right? You probably hear this every day, Matt.
Yep.
Someone's filed their own. So they're filing a trademark for the solid mount, class 20. I don't know what that is. I'm sure you do. For their active application dated 6 months earlier for rock solid. And they got a non-final office action. Are you following along on that? What does that mean?
Yeah, I am.
I'll put the results here. Looks like they have some of the results. They might have just copied from the office action.
Right now.
Okay, yeah, maybe go look it up. Look at Matt's live. He's looking this up.
Yeah. All right. So the solid mount, and this is in class 20. Hardware, namely non-metal brackets for general use. All right. So let's take a look at the office action quick. So an office action occurs when the USPTO finds an issue with the application during the examination process. So it could be small. It could be they want some clarification on the product name or the owner or the description of the product or the service. Or it could be larger, which is likelihood of confusion or a merely descriptive refusal. There's a whole bunch of them. So let me just take a look at the office action and see what we got. So office actions, when you get an office action, you have 6 months from the office action to respond. If you don't respond in that 6 months, you could potentially lose the trademark, or you ultimately will lose the trademark application. So I'm just looking at the office action really quickly here. Okay, so this is an interesting one because the USPTO has not formally issued a likelihood of confusion with this prior filed application. So this is what I would call almost like a suspension. So their USPTO is saying, hey, we're going to hold things up here a little bit. We have this other application that is basically in front of you at the USPTO, and we have to wait and see what happens with that application before we make a decision as to your trademark application. So there is the application for Rock Solid. I'm going to look them up quick too. And they're waiting basically to see if that trademark registers. So this is what we do when we talk to clients who are, going through the process themselves and running the issues. It's just kind of counseling them on how we can potentially get around this issue. So yeah, so it's a big application. There's 4 classes to it. There are metal materials in the application, so kind of similar. So basically at this point, what I would advise a client to do is that there's not much to do. We just have to wait and see if this other application actually goes through the process. If it does go through the process, then the USPTO examining attorney has to make a determination whether to issue a formal office action.
Okay, so they're going for the solid mount in class 20, and this is fascinating. I didn't know that it could be in a way sort of suspended or held up for rock solid, which is going for other classes.
Yep.
They aren't even going for direct 20.
No,
That's curious.
so all these different classes are potentially related, right? I'm not as familiar with like a class 20 and what that necessarily would be similar to. The classic example, the one we see a whole lot of is like jewelry and apparel, right?
Yep.
Those are big ones. Class 9 for like applications, mobile applications, and class 42 for software. Those are highly connected. But a lot of these materials products or materials applications, whether it's class 20, 19, they can bump up against each other if they're related, right? Because you can conceivably have the same type of product that's made out of textile or glass or metal or plastic potentially, and they can all basically be related, just made out of different materials.
Got it.
For this particular individual, I'll say one more thing. They did receive an office action. Specifically, they need to respond to a disclaimer requirement or a disclaimer request. So they do need to respond to the office action within 6 months. But there's nothing that needs to be due in terms of the prior filed application at this point. We need to just wait and see what happens there.
Okay, very good. Thank you, Matt. That's solid. I mean, I think to kind of bring it back around to the tax credit issue, I mean, if they're applying for trademark rights, they likely have to provide a specimen, right? They have to show that they're selling, or is that right? To be at this level?
Yeah, in order to get a registration at the Uspto, you basically have to prove that you're using the trademark in interstate commerce, basically selling it online, selling it down by the road. It's easy to do to prove that. But basically, you have to have a product for sale or a service that can be purchased. And just so to provide some further context of why it's so important to file these trademarks early, JD, that particular individual with the solid mount, they've been using that product name since 1997.
Wow.
But they only filed in 2021. The problem is Rock Solid has only been using their trademark since 2020, it looks like. At least that's their priority date. So, conceptually, like the solid mount applicant has better trademark rights. But they're going to be held up by this Rock Solid application because they filed first. So
let's say the horror of horrors happens for the solid mount. Rock Solid is going to get it because they filed first. So is it true that the solid mount would be limited in terms of their using of that mark, the solid mount, to the geographical area that they have history for?
Yes. I mean, technically, like from a common law perspective and federal perspective, like they would have some rights into where they've previously done business.
Right.
But they'd still have to prove those rights in court, right? And so, I mean, truly what's going to happen here is, let's say Rock Solid registers and the USPTO cites their registration against the solid mount. Well, then it's an uphill battle for that particular applicant, because they're going to either have to go with hat in hand to Rock Solid and say like, hey, like I got priority review, I got better use. I can either cancel your trademark or you can consent to my registration and coexist, or they have to go cancel it, right, to get their registration through the process. So it's not, because that gets
long story short, they should have filed way sooner. So if there was a company out there, the robot of tax, and they existed 10 years ago, a company like Tax Robot, Phil and Uche, we got you back on. If a company like Tax Robot were to file now and register their mark, they can actually take advantage of that protection, even though the robot of tax has been around for 10 years.
Yeah, so, and if you were working with Uche would have said, yeah, you need to go talk to Matt and JD over Bold and get that registered.
That'd be a crazy coincidence there.
Thank you, guys. I want to bring you back on before we round up our show. I mean, so again, thank you for being on and talking with our inventors and entrepreneurs about tax credits, how to get started, where to go, and please do visit taxrobot.ai. That's the place to go. Just plug in and just start the process. Even if you're not sure about whether you can claim anything, Phil and Uche will help you with that. Any closing remarks, you guys?
Yeah, absolutely. Just want to thank you again for having us on here. Definitely the R&D tax credit. We tell people it's one of the most complicated and convoluted sections of the Internal Revenue Code, but there's no need to stress about it. Just go ahead and contact us, and we'll go ahead and let you know if you qualify, give you an estimate, and help you work through that. So we appreciate the opportunity to spread the word about it and give people that education, that insight.
You bet. You're very welcome. And from Matt, myself, and everybody here at Bold Patents, wish you guys a great week. We'll see you next week, Wednesday at 9 a.m. for the Bold Today Show. Have a great week, everybody. Go big.